Hello, good afternoon, everybody, and thank you very much for joining the webinar today. This webinar is coming to you from BMA Law, which is an independent law firm established by the British Medical Association. We offer expert, cost-effective legal advice, and unlike other law firms, we operate on a not-for-profit basis, reinvesting any surplus back into services for doctors. This webinar will focus on CQC inspections and enforcement. My name is Errol Archer. I'm a consultant solicitor advocate with BMA Law. I've been qualified for nearly 30 years. I'm a specialist regulatory and healthcare lawyer, and I've had experience over the years working not only in private practice, advising organisations, providers and individuals, but also working in-house with central government and also in-house with regulatory bodies themselves. So what I can hopefully bring to my clients is an insight as to how the regulators themselves make decisions and operate. So the aims of today's session, there are 6 key aims of today's session. I'm going to look initially at CQC and GP practices as a particular service area. I want to talk through the statutory framework with you, then touch on the single assessment framework that was introduced from the beginning of last year. I'm then going to talk about how to handle the inspection on the day of inspection. Following the inspection, I'm going to then talk through the factual accuracy response process. And finally, I'm going to discuss CQC's enforcement powers. So, CQC issues an annual report every autumn called the State of Healthcare and Adult Social Care Report. The most recent one was issued in autumn, published in autumn of 2024. And it recognised well-documented and continuing challenges for general practice, primarily from a growing and ageing population with more complex health needs being presented to general practice. Key findings that were highlighted in the report are that there's been an increase in the number of patients registered with a GP practice, and that's increased by 5% from 60 million to 63 million. And unfortunately, at the same time, there's also been an increase in the more people waiting for more than 2 weeks for GP practices appointments, and that increase has been by 18% during the 4-year period 2020 to 2024. CQC recognises that there are concerns that this increased need will be putting potentially unsustainable pressure on the workforce. So, looking at the performance of general practice over the period 2023 to 2024, we can see from this slide that of those practices inspected, 90% of practices achieved an overall rating of good, 5% an overall rating of outstanding, 4% requires improvement, and 1% inadequate. The takeaway from this slide is that general practice performs particularly well in comparison to other health and care sectors. And this slide shows the comparison between general practice, adult social care, NHS and independent mental health, and NHS acute. And you will see that GP practices overall, 90% of those practices are rated overall as good in comparison to the ratings that have been allocated to other sectors. And if we drill a little deeper into the publication from last year, we can see that in relation to the 5 areas of inspection: safe, effective, caring, responsive and well-led, GP practices, 93% of GP practices achieved a rating of good in safe, In effective, 92% achieved a rating of good, 95% in caring, 80% in responsive, and 90% in well-led. And these are reassuringly relatively high ratings in comparison to other providers. So general practice is in a relatively good position in relation to those other health and care providers. So moving on now to the statutory framework that underpins CQC. CQC is a product of statute. It's a regulator created by an Act of Parliament, created by the Health and Social Care Act 2008. Therefore, its powers are specified in that Act and nowhere else. It has no other powers than those functions and powers specified in the Act. As a statutory body, it is subject to challenge by way of judicial review, and I'll talk a little bit more about this as we go through the presentation. So, as a statutory body, it must comply with public law requirements. But the relevance of this slide is that we can see from Section 2, subsection 2b, that CQC has the functions of review and investigation. And it's under this function that CQC conducts its inspections. And in exercising these functions, Section 3 of the Act explains the objectives that CQC must bear in mind and must seek to achieve in discharging its functions. You'll see here that the first objective is to protect and promote the health, safety and welfare of people who use health and social care services. But what I particularly wanted to draw out from this slide is the function at 2A, that it must perform its functions for the general purpose of encouraging the improvement of health and social care services. So encouraging improvement is part and parcel of CQC's objectives. CQC would not describe itself as an improvement agency, but it certainly has a role in supporting practices that require, that have scope for improvement to improve. There are four main streams of work that CQC carries out. The focus today is on inspection, but monitoring is integral to this function. Monitoring of providers informs CQC as to which providers to inspect, when to inspect them, and also whether an inspection should be carried out urgently. And also through its monitoring, it can identify which areas it may need to focus on at each particular inspection. So inspection and monitoring are very closely linked. And it, of course, exercises, it has its other streams of work of registration, where a provider comes into the market and is going to be providing regulated activities. And also, on the other side, it has its enforcement stream of work. As I mentioned earlier, there is a question mark over how much of an improvement agency role CQC should play. So I want to talk a little bit more about the statutory framework in holding CQC to account. So CQC is an extremely powerful regulator. It inspects providers regularly, and it can take action to cancel registration where it feels that a provider is not performing. So how can CQC be held to account? Well, it can be held to account through the legal process of judicial review. And this is the legal process through which the executive, i.e. government, public bodies such as CQC, can be held to account by citizens of the state, by individuals, or by organisations. So judicial review subjects the statutory bodies, subjects CQC, to the rule of law. And the rule of law means that CQC and all other public bodies must act in a way that is legal, reasonable, rational, and they must act with procedural propriety. So where, in order to act legally, CQC must ensure that it complies with any rules and guidance that are in place. It must act in a way that it must ensure that it considers only relevant information in its decision making during inspections, for example. It must exclude irrelevant information. In order to be acting legally, it must be acting within the powers given to it by statute. And as regards acting reasonably and rationally, the test for whether CQC has acted reasonably in any particular situation is whether it has acted so unreasonably in granting a particular rating or in the way it's conducted an inspection or the enforcement action it's decided to take, is whether it has acted so unreasonably that no reasonable regulator could ever come to that decision. So this sense of reasonableness sets a high bar, and this is the legal bar for assessing reasonableness in the acts of the Care Quality Commission and other public bodies. It's of course not, there may be many occasions when you feel that an inspector has acted unreasonably in the layman's use of the term, but in terms of whether CQC has actually acted unreasonably as regards public law, it's this higher standard that is applied. The CQC must, of course, act with procedural propriety. So if, for example, it issues a practice with a notice of proposal or a notice of decision, it must also provide you with information on which you're able to prepare your own representations or an appeal to the tribunal. So it's got to follow the correct procedure that's in place. And its decisions must be proportionate, evidence-based, and CQC must give reasons for its decisions. So we can move on now to the single assessment framework for inspection. The single assessment framework was rolled out from January of last year, January 2024, and its aim was to replace the previous inspection model, which included key lines of inquiries, the CLOEs, and the ratings characteristics. Some of you may be aware that, unfortunately, the rollout of this new model of inspection and the new framework has not gone at all well, and it hasn't met the regulators' objectives, and I'll talk a little bit more about that later on. But it does remain in place, and CQC is continuing to inspect under this new framework, although there will be more changes during the course of this year. So the single assessment framework itself is intended to replace what we previously had, which was a number of different inspection models for different areas of inspection. So for NHS trusts, for general practice, for care homes and domiciliary care, there were slightly different inspection models. So the single assessment framework was intended to simplify that. There's one single framework that applies to all sectors and also applies to the registration, to inspection and to enforcement. So that was the aim. There was intended to be a move towards an ongoing assessment of risk and a move away from assessing risk at predetermined inspection on-site inspections. There was the key lines of inquiries have been removed and replaced with 34 topic areas against which practices will be assessed for compliance. The ratings remain the same, those 4 single word ratings: outstanding, good, requires improvement, and inadequate. The change now is that those ratings are underpinned by a numerical assessment of compliance. Ratings should also be updated more often because CQC has got a greater focus on the ongoing assessment of risk. and they will be publishing shorter inspection reports, which they intend will be more easily accessible by the public and also by providers. So looking at the 34 topic areas, these break down as follows. We can see that the safe and well-led categories each have 8 topic areas within those categories for inspection. The responsive category has 7 topic areas, effective 6, and caring 5. There isn't time during this webinar to go into detail about the topic areas and the quality statements, but there is more information on CQC's website. Within each of the topic areas, there are a number of quality statements, and these quality statements are statements of quality against which the inspectors will assess your delivery of care at your practice. CQC now has 6 sources of evidence to which it will look to reach its judgments of compliance. Look for evidence as to the quality of service. They will seek feedback from staff. They will seek feedback from partners, local authorities and ICBs, for example. They will, of course, on-site inspections, they will observe the delivery of care and the operation of your practice. They'll be looking at your processes, so they'll look at the policies you have in place. For example, they'll be looking at your policies and processes around dealing with safeguarding events, for example. They'll also be looking at outcomes within your service. So inspectors will allocate scores to each quality statement, a score between 4 and 1, with 4 being the highest, 1 being the lowest. 4 will equate to an exceptional standard of compliance, 3 a good standard, 2 a shortfall, and 1 a significant shortfall. Once they've allocated these scores, they will be aggregated and calculated as a percentage of the total possible score within that topic area. And you can see from this slide that those percentages are converted back to give you your single word rating. So if you score over 87%, you'd receive a rating of outstanding, and between 63 to 87%, a rating of good. So the new single assessment framework and CQC's new approach to inspections has resulted in CQC's inspectors' role changing slightly and moving away from conducting traditional on-site inspections, away from a focus solely on that to a focus more on the ongoing assessment of care compliance. There's a focus on achieving an ongoing up-to-date view of quality, risk and safety. Although bear in mind that on-site inspections can be triggered by a range of source information from whistleblowing, from feedback from parties, from CQC observing an increased number of statutory notifications, for example. And CQC's inspections are now intended to be more targeted. So this moves away from inspections based on a set predetermined frequency to targeted inspections based on assessment of risk. So previously, as I mentioned, CQC the frequency of inspections would be determined by a provider's overall rating. If you were rated good, for example, you normally wouldn't be inspecting more frequently than a 2-year period. However, now the inspection frequency is based on CQC's current rating on the current assessment of risk of your service. There are two types of inspection. There are planned inspections and responsive inspections. Planned inspections will be determined by CQC's assessment of risk. So inspectors covering a particular area will assess from their monitoring of practices and providers in that area, assess the relative risk, and they will then work out their programme of inspection for the next period. Planned inspections for GP practices are normally announced. You'll normally get 1 or 2 weeks' notice to avoid disruption to patients. CQC will also use responsive inspections where they receive, for example, information from a whistleblower, information around safeguarding from a local authority, and they will then be responsive and they may highlight or prioritise the inspection of a particular practice. So I mentioned earlier on that the rollout of the single assessment framework did not go particularly well during the course of last year. The previous government had commissioned Dr. Penny Dash to conduct a review into the operational effectiveness of the Care Quality Commission, and she published her interim report on the 26th of July of last year. The incoming Health and Social Care Secretary, Wes Streeting, published a statement on the same date, and he stated that, and to quote, "It's clear to me the CQC is not fit for purpose." So this is a pretty shocking and concerning statement from the Health and Social Care Secretary in relation to one of the key regulators in the country. And it clearly has been a bit of a wake-up call for CQC itself and also for the government. And as a consequence of that, Wes Streeting, Secretary of State, in addition to the Penny Dash review being undertaken, he commissioned a report from Professor Sir Mike Richards to look in particular at the inspection process. So Dr. Penny Dash published her interim report on the 26th of July, and she highlighted a lack of experience among inspectors. And a couple of examples of these. One was that there was an inspector who was inspecting a hospital despite never having visited a hospital before, rather shocking in and of itself. Another inspector had apparently conducted an inspection of a care home, having never met a person with dementia before. Penny Dash published her full report on the 17th of October 2024 with a number of conclusions. She concluded that there were significant delays in producing reports and that the inspection reports themselves were of poor quality. There were concerns around the single assessment framework and its application. There was a lack of clarity regarding how ratings are calculated and concerning the use of the outcome of previous inspections to be aggregated with the outcomes from current inspections to provide your overall rating. And of course, this is clearly misleading to use ratings in certain categories of inspection. So if CQC came out to inspect and look at just the categories of safe and well led, and they allocated ratings to those single word ratings, they would then rely on the ratings for the other three categories for effective, caring and responsive from the previous inspection, which may have been 2 or 3 years prior to the latest inspection. And they would use that combination of ratings to give you an overall rating. And that could only, I mean, at best, that would be misleading in that it wouldn't be providing an up-to-date rating for the service. So just bear with me a moment. I'm just going back to the previous slide. So in her full report, Dr. Penny Dash also highlighted concerns, I'll just come to those, that CQC could do more to support improvements in quality across the health and care sector. for example, through the description of best practice and sharing of that with providers, and through greater sharing of new models of care delivery. Professor Sir Mike Richards published his findings on the 15th of October of last year, and he stated that CQC has been unable to fulfill its primary purpose, which is to ensure health and care services provide people with safe, effective, compassionate, high-quality care. He highlighted that far fewer inspections have been carried out and that clinical leadership and oversight of the inspection programme had been lost. He commented that the single assessment framework is far too complex and there are elements of the quality statements that are confusing both to not only to providers but also to CQC inspectors themselves. And that the calculating the scores and looking at the evidence categories were causing major delays in CQC's inspectors actually completing the writing up of those reports. He also said that processes to ensure consistency of judgments and the adequacy of relevant evidence, which is vital to good regulation, had been adversely affected by the downgrading and the dilution of quality assurance processes. So clearly the single assessment framework has had issues over the last year, and what Professor Sir Mike Richards will be doing is working with CQC's leadership team over the course of this year to tweak the process to make operational changes as and where required, and you will see those feed through during the course of this year. So now moving on to the day of inspection. So inspectors will meet with the registered manager initially at the start of the inspection. And why I pulled this slide up is just to remind everybody of the first impressions. So clearly, in an ideal world, we wouldn't be welcoming the inspectors into a room that's as messy as the one on this slide. You'd want a nice, clean, warm room to welcome them into and to get the inspection off to a good footing. I'm just moving over to the next slide now. So at the beginning of the inspection, you'll be invited to give a provider presentation, and this is your chance to set the scene for the inspection, to share some good news stories, if you had some positive patient feedback, all those thank you cards that general practice received during the course of the year. It's a real opportunity to get over a really positive impression of your practices, to share with CQC's inspectors any examples of outstanding care delivery, any particularly outstanding outcomes that you've had. Have you introduced any new services during this last period between the last inspection? Do you have some new ways of working that are having a positive impact on how you deliver care? Again, these are key things that can be shared and should be shared with the inspector at this initial meeting. And it's your own view of your practice's performance. So nobody knows your practice as well as you do. So it's an opportunity not only to demonstrate how well your practice has done, but also to demonstrate your knowledge of the 5 key areas of inspection that CQC will be looking at, and the underpinning quality statements, and also your knowledge of the relevant population groups that your practice deals with. So be confident, of course. As I say, no one knows the practice better than you. Ideally, if you can, try to prepare something in advance. So whether it's a short presentation using your laptop, whether it's a handout, but be prepared so that you can give a good impression to the inspectors and inspire their confidence at the very start of the interview. And of course, be helpful. Let them know housekeeping issues, where the toilets are, kitchen area, fire exits, all that sort of stuff. So that's a golden opportunity to get things started on a positive footing. So CQC will provide any urgent feedback as the inspection progresses, and you should aim to take immediate action to address any urgent concerns that are raised. So, for example, if they found, for example, out-of-date medication or resuscitation equipment that had not been checked as it should have done, whether there are issues around patient confidentiality, any urgent issues, address them straight away. Deal with them immediately and ensure that ideally by the end of the day of inspection, you've been able to provide the inspectors with evidence that that issue or concern has been resolved, or that you're at least in the process of resolving it rapidly. There'll usually be a halfway review where CQC will sit your registered manager down or the responsible partner. We'll give you some feedback, and it's again another opportunity for you to try and find out precisely how things have been going. There will be formal feedback at the end of the visit. Well, CQC will sum up, the inspectors will sum up any issues that they found, again, any issues of concern. They should highlight any additional evidence that they would require you to provide to them after once they've left. And if so, prioritise this. Aim to provide any additional evidence within 24 to 48 hours following the inspection. CQC should indicate whether they're planning any follow-up inspection of another inspection day of your practice, in which case, try to find out what issues they're concerned about so that you can prepare accordingly. And it's a great opportunity for you to be completely clear as to what evidence CQC need in order to reach a fair assessment of the quality of the level of compliance of your practice. So make the most of that feedback session. Ideally, if you can have somebody sat in with the lead person in your practice to make a note as to what's discussed, that would also help. And this slide is really just to emphasize those last impressions. So at the end of an exhausting day of inspection, you may feel more like saying goodbye along the lines of this lady in this on this slide, but of course try to say goodbye and sign off on the day in a positive way, to sort of finish on a high. And yes, the pictures in this slide are meant in jest, but again, if you can finish on a high and leave a good lasting impression, that is only going to help the inspector's analysis and assessment and conclusions and view of your service. Ideally, if you can thank them for the inspection, a properly conducted inspection by professional inspectors who are at the top of their game, who are listening to you and conducting the inspection appropriately, should really be a valuable learning opportunity for you as well. And if not that, it should be confirmation that you're doing things well. So thank them, and then hopefully, fingers crossed, look forward to the outcome of the inspection. So I'm going to move on now to the factual accuracy response process. And as you may know, you will receive the draft report usually within 3 weeks to 6 weeks following the inspection. The production of reports over the last year have been particularly slow, but once you receive the draft report, you'll have only 10 working days to review it and respond to it. And in terms of your review of the of the draft inspection report, my advice would be to review it paragraph by paragraph. You need to adopt an objective and forensic approach to your process of considering the draft report. Evidence is absolutely key. If there are any items that you disagree with or where you feel the inspectors have misunderstood the position, you will need to find and provide evidence to demonstrate the correct position. You may feel that because of the pressure of time, you need additional support. If you don't have resources within your practice to go through the factual accuracy process, you may want to call on a lawyer like myself to provide support. However you decide to deal with the factual accuracy response, please just bear in mind that those 10 working days can pass very, very quickly. And ideally, I would advise to set aside at least 1 day so once you've drafted your response, set aside 1 day to submit that through the online portal and to submit any of your evidence. So I'm just going to move on to the next slide here. And this shows the process that I would recommend you take. So you review the draft report paragraph by paragraph. Initially note any typographical errors or numerical errors. So they may have noted the number of staff in your practice incorrectly. There may be some simple errors they've got. Highlight those and correct them. Then have a look at whether there are any statements that are in the draft report, any findings or conclusions the inspectors have made that are factually inaccurate. Were there any statements that reveal a misunderstanding on the inspector's part? They may have misread or misunderstood patient records they've looked at. They may not have understood the context of a particular service that you're providing. If that's the case, then that's another item you want to flag up and provide a response on. So prepare your response to each erroneous statement or each factual inaccuracy, and be sure where you are asserting that the factual position is different from what is in the inspection report, that you cross-refer to evidence to back up what you say. Without evidence, nothing is going to change in the draft report. No scores or ratings will change. You need evidence to back that up, whether it's copies from notes, whether it's a new policy that the inspector didn't see, whatever it is, ensure that there's evidence to support what you have to say. There are word limits for submitting a factual accuracy response, so factor in time to revise your drafting. So if you may need to revise the drafting of your factual accuracy response several times to get it below the relevant word limit. So please factor in time for that before that deadline runs out. So once you put the factual accuracy response in, CQC will consider it. They will take on board any comments that they feel are justified. Then they will provide you with the final report that they will proceed to publish, and you will then have the opportunity to make a rating review request. Now, a rating review request looks only at whether CQC has followed its own processes in awarding scores and ratings properly. So has it properly considered your factual accuracy response? Has it considered all the evidence you put in and all that relevant evidence you put in during the factual accuracy response, for example? So it's only going to be considering the process. It's not an opportunity to have another bite of the apple of challenging the evidence itself or challenging judgments, because you'll have had your opportunity to do that during the earlier factual accuracy stage. Frustratingly, the ratings review process takes place after CQC have published your report, but if they do agree that they have not followed their processes properly and they make changes to the report as a consequence of that, they will pull down the erroneous report and replace it with your new report and rating. Final word on this is please remember to display your ratings in your service in a prominent position and on your website it's a criminal offence not to do so, and CQC have been known to threaten to impose fixed penalty notices for failure to do this. So that brings us to the end of that section and on to enforcement powers that CQC has. So CQC is continuing to use its full range of enforcement powers, and it's doing this under the new regulatory approach. CQC has two sets of powers available to it. It's got civil powers. These are the powers that it uses to issue warning notices, notices of proposal or notices of decision, to impose conditions or to require cancellation of a practice. On the civil side, those at the worst end of the scale, an appeal against a notice of decision would end up in the civil courts, in the Care Standards Tribunal. CQC also has criminal powers available to it. For example, it can issue fixed penalty notices, and it can bring prosecutions, and such prosecutions will be brought in the magistrate's court. And it can issue fines in the magistrate's court. The police and the CPS can, of course, bring prosecutions where there have been serious failings that amount to neglect or abuse, but they don't come within the scope of CQC, but there are prosecutions that can be brought by the police and CPS in respect of those matters. Where CQC rates a service requires improvement or lower for the first time, its guidance states that it will write to inform you that any subsequent rating of requires improvement will amount to a breach of Regulation 17. It will want to share that information. It will share that information with commissioners at the same time. Where there's a breach of a regulation, CQC states that it will consider proportionate enforcement action in accordance with its published enforcement policy. CQC may ask you to complete and return within 28 days, usually, an improvement action plan to demonstrate how and by when you're going to make improvements to the quality and/or safety of the service, and ideally with a view to achieving an overall rating of at least good. CQC may also request a meeting with you, with your registered manager usually, and with commissioners to discuss their concerns, improvements needed, and any support that may be available to assist you. CQC will consider prosecutions where there is evidence that any of the following apply. Where they find that services have resulted in avoidable harm, whether that is physical or psychological, to an individual, to a patient, where they find that a person using a service has been exposed to the risk of serious harm, CQC will move to prosecute. Just bear with me one moment. Just going to go back to the previous slide. My apologies for that. Just one moment. Yes, so they will prosecute if there's been avoidable harm, if they feel there's evidence to show that a person has been exposed to a significant risk of such harm, where there's evidence that service user patient's property being stolen, for example. That doesn't particularly apply to general practice, it applies more to care homes, for example. Where a service has been provided to an individual without informed consent, or where there's been a failure to comply with a requirement of a notice of proposal or requirement for a warning notice, that can amount to a criminal offence and could be subject to prosecution. Just bear with me a moment as the slide moves on. So I was focusing there on CQC's criminal powers to issue penalty notices or to bring prosecutions. This slide looks at its civil powers. Its key civil powers are the powers, civil powers of enforcement are to issue a notice of proposal or a notice of decision. There's a two-step process where they feel that providers fail to comply with the regulations or is in breach of regulation. And they can use a notice of proposal to impose or vary conditions on your registration, to suspend your registration, or to cancel your registration. They can, of course, if they refuse an application for registration, they will also issue a notice of proposal. You'll have a 28-day period to prepare representations to a notice of proposal, and you'll be doing that with a view to persuading CQC not to take any further enforcement action. The approach to drafting and preparing your representations is similar in a way to how you would prepare your factual accuracy response. So you would want to review the notice paragraph by paragraph, and crucially identify and provide evidence in support of your either improvements that you've implemented or of your compliance as well. You will also want to present evidence where you feel that there's something in the notice of proposal that is simply incorrect. So where you would want to refute a criticism or a concern raised by CQC, you will need to present them with evidence to support your representation. Now, from experience, notices of proposal can run from 4 to 5 sides of A4 through to 20 to 25 sides of A4, a lot of detailed information. So depending on the number of concerns raised by CQC, if you are to prepare effective representations, this can be extremely time consuming. So although you'll have a 28-day period to put in representations, please don't underestimate how long that process may take. And of course, we're available here to provide support if you feel that that would be helpful. So if once CQC have reviewed your representations, if they're satisfied, they will not adopt the notice of proposal and they will bring the enforcement action to an end. Where they're not satisfied with what you've put forward, they will proceed to issue a notice of decision. So that can be a notice of decision to cancel registration or to suspend your registration, for example. You will have a right of appeal to the first tier tribunal, so the Care Standards Tribunal that sits within the first tier tribunal. You've got 28 days to prepare your appeal reasons and to submit those in detail to the tribunal. There's a specific form that you'll need to complete, and certainly if you get to that stage, I would strongly recommend that you get some legal support in terms of completing and submitting your appeal documentation and your appeal reasons. As with any litigation, it's really crucial to adopt a strategic approach to the appeal. You want to consider what your tactics will be, and ideally, I would advise you adopt a strategy of putting in a strong response at your earliest opportunity. It's a false economy to put in a quick appeal, a short, concise appeal, and then end up in a hearing many months down the line. What you want to do is put in your strongest appeal reasons and evidence at the first opportunity. To give you an idea of the timescales, if an appeal was to run all the way to a final hearing, the final hearing is not likely to take place until between 5 to 7 months after you submit your appeal. And at that final appeal hearing, the panel would be considering your degree of compliance based on evidence at the date of the hearing. So importantly and helpfully, what this does is provide you with a period of time, a period potentially of 5 months, to implement improvements, to build up a body of evidence to demonstrate that you are now compliant. Strategically, that's something useful to be aware of, that you will have time to implement improvements. But ideally, in drafting your appeal reasons, you want to be providing sufficient reassurance to CQC's legal team and to their inspectors that you're on a very, very strong and committed path to achieving and sustaining compliance. And what you would want to be doing is to be liaising with CQC's legal team to encourage them to agree to applying to the tribunal for a stay of proceedings. So what this means is that the tribunal, once you put the appeal in, the tribunal would put a pause to the appeal. They will put it on hold for example, 3 or 4 months, and this would provide you time to implement your improvements, and it would provide CQC time to come back to re-inspect your practice to assess whether those improvements have actually been implemented. Ideally, if CQC is satisfied that they have, we would then negotiate with CQC's lawyers to present the tribunal with what's referred to as a consent order, a draft consent order for the tribunal judge to consider and sign off on, and that would allow your appeal and bring the appeal process and the enforcement action to an end. So from my perspective, a successful appeal is one that never actually ends up at the final hearing, because we've put in such strong and convincing reasons with the appeal documentation that CQC are assured by this, and they agree to a consent order to allow the appeal. CQC has the option to make an application to seek an order for urgent cancellation, where there is evidence that not cancelling the registration would pose a serious immediate risk to a person's life, health, or well-being. Where CQC feels that this is the case, they will make an application to the magistrates' court. You may or may not be given notice of this depending on the urgency, and where the magistrate is satisfied with CQC's application, they will issue an order that will take immediate effect, and your registration will come to an end, and you will have to stop delivering your service and conducting that regulated activity or those regulated activities. You will, however, even with an urgent cancellation order, you have a right to appeal to the tribunal within 28 days, and you would be seeking for the tribunal to make an order that the urgent cancellation order should cease to have effect, so that you can then resume your practice. So that brings this webinar to an end. There are further resources available to you. The BMA website itself has some really useful information on preparing for a CQC inspection and handling the day of a CQC inspection. And I would recommend that you refer to that. CQC's own website has a lot of information around the quality statements. CQC had talked about reintroducing inspection characteristics so that you would have an idea as to what good care, what a good rating looks like in a practice. They haven't introduced those yet, but I understand that they will be introducing those over the course of the coming year. Nigel's surgery contains tips and mythbusters on CQC's website, and that can be a really useful source of information as well. So here's a brief recap of the webinar. Thank you very much for joining. If you have any questions, if you could please feel free to let me know. I'd be more than happy to answer any questions you have. I'm also more than happy to take informal queries from BMA members. If you have concerns around CQC inspection, compliance or regulation, please feel free to get in touch. Thank you very much for joining this webinar, and goodbye.